When I first heard that there was an issue of what happens to the ICTY's archives, I heard that what happens to the archives of various institutions and UN organizations is always the same. Archives go to a hardly accessible place somewhere in New York. But then we heard from the ICTY staff, no, this is so valuable. This is so significant to victims. This is so important to post-war communities that we have to find a different solution. There was a discussion that has been going on for years now. They have not got the civil society organizations involved or the governments of Croatia and other countries of the region, but still it did get them involved, the NGOs, the victims' organizations, the governments, in a discussion. So there are some open issues still, there are some dilemmas that need to be discussed, and I am happy about this opportunity to talk about the archives, the residual mechanism, and the role of information centers and residual mechanisms. So, Ms. Gabrielle McIntyre, could you share a few opening remarks?
So, as you heard from Martin today, the archives will actually be situated with the residual mechanism. So they're not going to be taken away and hidden somewhere. They will be situated with the residual mechanism. The Security Council made that decision when it established the residual mechanism in Security Council Resolution 1966. In that resolution, it basically said the mechanism will be responsible for the management, the preservation, and the access to the archives. So while the archives will be situated with the residual mechanism in The Hague, the Security Council also considered that there needed to be another way to make the materials more accessible to people that were interested in them, especially the people from the region of the former Yugoslavia. So in the same resolution, the Security Council also mandated the tribunal to facilitate the establishment of information centres. And information centres will be places which contain the public record of the tribunal so that people can access it. But ironically, you can actually access the public record of the tribunal already through its website, through its webpage. But from what we've heard today, it seems that that's not sufficient because people aren't getting information. The sources that they're relying on locally are unreliable sources of information. So hopefully the establishment of information centres will make the information more visible and easily accessible to you. With respect to national judiciaries and their cases, prosecuting their cases, the residual mechanism statute contains a provision which puts an obligation on the residual mechanism to cooperate with national judiciaries. Now, the ICTY statute didn't have that obligation, so this is a move forward. While the ICTY statute did not have that obligation, one judge in particular, I would say Judge Pokar, recognised very early on that national judiciaries would have to take over the work and the tribunal had to take steps to make sure they could do that. So he introduced a rule amendment into the rules of the ICTY that allowed national judiciaries to directly access the chambers, to get access to information, to ask for variation of protective measures. So there will be the same facility available to national prosecutors and defence as well to go through the national judiciaries to petition for access. So the focus of the tribunal in going forward is in making sure that as much of the record as possible is accessible to you in a visible way, and information centres are sort of aiming to do that. I'll pass on to you.
Mr. Gordan Markotic, Assistant Minister of Justice in Croatia, who has been dealing with this issue through various functions that he had. So what's the opinion of the government of Croatia?
Thank you. From the very beginning, the government of the Republic of Croatia had a special interest to find a sustainable solution and a practical solution for saving the archives and the residual mechanism. The basic assumption of ours was that it needs to be a safe place and that there needs to be access made available for everyone. And this view of ours is a reflection of the importance we hold for the archives. And I think that's one of the most important functions of the future residual mechanism. The negotiations have been taking quite a long time, as the colleague has explained. But let me say that in 2010, and to be more specific, on the 22nd of December 2010, the UN's resolution was adopted, which, among other things, talks about the residual mechanism, but it deals with the question of archives. And the resolution more or less says that the archives of the ICTY, and as well as the International Criminal Tribunal for Rwanda, will be owned after that by the UN. It will be of full integrity, and that the residual mechanism will be responsible for the management as well as for safekeeping and access. And it also says that the archives will be located in one of the branches of the residual mechanism. So it can be either the Netherlands or Rwanda. Of course, when it comes to us, it will be kept in the Netherlands, I hope, certainly. And in managing these archives, there is confidential information confidential, especially when it comes to protected witnesses, and especially when it comes to information which are gained on a confidential basis. So it is set out by this UN's resolution, and this resolution of the UN corresponded to a large extent with Croatia's views on that matter. From the very beginning, we kept saying that the archives should be centralized. And we were in favor of having the archives in one of the institutions of the UN where there already are premises and there are some other archives. Why? In order to make sure that the highest standards are met. There were some initiatives to place the archives in the region, and some people said that it's a symbolic gesture, the historic right of certain countries. But from the very beginning, we were against that, because we still have political relationships which are quite complex in the region, and we were afraid that if we place archives in any of the countries which materials were collected from, which is Croatia, Serbia, and Bosnia-Herzegovina, that in that case, access will not be equal to all. We also thought that it might happen in those cases that the archives get abused by one side against the other. That's why we supported the option to have the international center based in the UN and controlled by the UN. Alongside the archives of the ICTY, we also wanted to have all the documents and all the evidence to be kept there, which were generated through public sessions. We were also of the view that those documents or evidence which were treated in a confidential manner by the ICTY or were presented during closed session or without public presence, that these archives should go back and should be given back to the countries that provided these documents. Because these are very confidential, very classified documents, which on one hand can be important today for national security reasons, which is mentioned in Article 54 bis of the Rules of Procedure and Evidence of the ICTY. Or these documents and evidence can be obtained in a confidential manner by the prosecutor, which is mentioned in Article 70 of the same rules. What is important for the future use of the archives, from the Croatia's point of view, is that we would like future archives, the data which are unlimited and the documentation which is public and which was generated by Croatia. We think it should be made available to the national institutions of all countries. We have the state archives. We have the assistant director here. He's going to say something more later on. And we also have the documentation center of the Homeland War. And we believe that these two institutions are the right ones to hold these archives or have access to it. And we hold the same view for the documentation which was generated for the defense of indictees. These are huge private archives at this point, and Croatia believes that these documents should be given back to the country, and then the country should dispose of these documents and not have them anymore in private hands. Why is that important? It's important not just because of history, because these documents are part of our recent history. It is important to further prosecute war crimes. Regardless of the fact that there's been excellent cooperation between national prosecution offices with the ICTY, for future prosecutions, it would be good to have a certain database of documents, especially the most confidential one and the most classified ones, which are kept then by the countries which generated these documents. What about the public? What should we do to make sure that the public has access to all these documents? Now we come to the issue of information centers. It is true that currently on the ICTY's webpage, you can have access to most documents, to quite a large extent. However, I must say that the web page is quite complicated. You probably need a special training to use the web page of the ICTY. I'm saying that from empirical experience, because my office, for a number of years, has been dealing with the cooperation with ICTY. And we did several times have lots of problems to find some documents because it's quite complicated. And that's why from the very beginning, our view was to set up information centers throughout the region. These information centers would then contain data from the ICTY, but it would be made available in local languages. These documents and data would be different motions, different court decisions, different testimonies, transcripts, audio and visual recordings. Apart from that, there could be also a library, which would then contain copies of, for example, all decisions of the ICTY. It could also contain books about international humanitarian law, books about international criminal law, books about procedural law, books about human rights. So that would be some sort of a point of reference, which could be used not only by scientists, historians, but also by victims and NGOs who deal with those issues. In this discussion on information center, our conclusion was that not all countries have the same interest for the same type of information centers. That's why there was this idea to have 4 basic models. The first model was the basic model to have access to documentation, which is public documentation held by the ICTY, which I've just talked about, and which was the Croatian option, or the option that Croatia favored. We have a project which is already ready, that if the information center is in Croatia, should be part of the law faculty. We thought that would be the best place to situate that sort of documentation. It will not be part of the faculty itself. It will be on a different location, but young legal professionals would work there, and they will be able to help others in accessing and interpreting different documents, which will then be part of the information center. They will be able to help people in accessing, interpreting archives and all the documents there. The second model was the so-called reconciliation model. It was called the reconciliation model. And this model was supposed to be used to raise public awareness about the work that the ICTY did, as well as to raise awareness about the work of the national courts, especially in the field of prosecuting war crimes. According to this model, roundtables would be organized, videos would be shown, movies would be shown, seminars would be organized, as well as public debates. In that way, this model would make sure that we have broad participation of all interested stakeholders, ranging from the victims to scientists. There is a lot of interest for this model by Bosnia and Herzegovina, or to be more specific, the Federation of Bosnia and Herzegovina, because opinions in Bosnia are always divided between the Federation and the Republic of Srpska. And the same thing happened in this case. There was another model. That was the model to support the legal profession and the civil society. This model was designed in such a way that information centers facilitate presentations and lectures and roundtables about the work of the court itself, the work of the tribunal. And these information centers would be then intended for those professions that deal with war crimes, judges, prosecutors, and sometimes historians. When it comes to this model, Banja Luka was interested, I'm talking about the Republic of Srpska, to introduce this model. And the last model was the so-called the exhibition model, which means that there would be a permanent exhibition of public nature, which would talk about the work of the ICTY, but not only ICTY, the national judiciary too, in prosecuting war crimes. That kind of exhibition would contain different video footage, audio material, written documents, but it would primarily be used to inform the public and journalists to a large extent. In a certain way, this model would be used for the purpose of reconciliation, just like the model which was called the reconciliation model. As far as the information centers are concerned, many activities have been undertaken. It all started in September 2010. We had 2 large conferences since then. The countries from this region decided it should be a regional project existing in all 3 countries. It should be funded in a transitional period by the international community for at least 5 years. And the idea was to have staff in information centers who would be then trained by the ICTY. And more or less, we talked about local staff who, after this training, would then be able to work in the information centers. The problem is that not all countries have the same views on information centers. Some countries still haven't decided whether they want information centers on their territory or not. What's important is not that only one country should accept. All 3 countries from the region should accept this idea of information center. Only in that case it would make sense. In that case, you would then have a regional project which provides countries with equal databases as a starting point to set up similar information centers. Thank you. Thank you very much. I'd like to give the floor to Mr. Monacic from the law faculty to tell us something about his perspective. First of all, I'd like to say hi to everyone. I'd like to also thank the organizers to say something at this conference. I have to say that for me as a lawyer, it would be much easier to talk about the legal legacy of the ICTY. And we would then be able to discuss about organizational legacy, since that was the first court which was set up by the Security Council. And this model of ad hoc tribunals has certain advantages compared to all other international criminal courts, which are international because it can put pressure on governments and countries and those who are directly related to a conflict zone. And it can force people to cooperate. We could also talk about substantive law influences and the influences on the procedural law, on the work of other international courts, as well as the national courts. And there is a large impact of procedural law because it's a mixture of 2 models, the common law model and the civil law model. So the tribunal, the ICTY, has changed its rules of procedure and evidence about 50 times. So we could talk about it from the context of creating an effective system of criminal proceedings at the international level. And as part of the completion strategy, there are some views on what should be done with other courts and the residual mechanism. And residual functions, of course, have to exist even when the court stops to work. So that's also important for the archives. The second thing I'd like to say, and which could perhaps be of more interest to the region of former Yugoslavia, are issues of the influence or the impact of the court if you look at the broader context of post-conflict justice. We can discuss to what extent the tribunal has brought peace. We can see to what extent the tribunal has brought justice to these countries and to what extent it identified truth. And as the last part of the post-conflict justice, we could talk to what extent the tribunal has brought upon us reconciliation. When it comes to the identification of the truth, somebody has already said that truth for historians is only one source of information. And then other sources paired up with that can give a complete picture. Because court trials in itself are not focused on the truth and the full truth, because the court deals with criminal responsibility of alleged perpetrators in a particular case. Apart from that, the inability of the court to identify the truth also has an impact on the type of proceedings brought before the court. And we can say that the common law procedure is not so favorable for full truth or complete truth. And there is also the completion strategy, which has an effect, and the prosecutor's work, which has an effect on that. All of this disables the court to identify the truth fully. When it comes to reconciliation and the importance of archives, maybe the importance of archives is more important in the field of post-conflict justice, to identify the truth and also to bring about reconciliation. if we talk about beneficiaries of the archives, we can distinguish between primary and secondary users. Primary users are those who are related to pending trials. The residual mechanism also should provide all materials in the future, and part of the cases in the future will be held before national courts too. So the national bodies of criminal justice are the primary users of the archives. After the completion of the ICTY, these archives should be made accessible for further prosecutions and other related issues. The second group of users are so-called secondary users, which includes victims, population at large, scientists, researchers, historians, experts of political sciences, people who want to keep a memory of a certain event, either through creating training materials or something else. For these target groups, after the first stage, which could last some time, secondary users afterwards will be more important. Of course, the importance is very high of the archives. At the same time, we need to see what will be the level of access, because you have different types of users which will probably have different levels of access, because you need to make it possible for a person to be entitled to information, but at the same time to protect other interests, as it has been mentioned by my colleague. The protection of the archives is also of extreme importance. Mr. Markotic talked about the fact that it should be kept in a safe place. There is an example from 2006 when in Timor-Leste there was a breaking and entry into the archives of the Serious Crimes Unit, where after the breaking, a part of the archives went missing. Such archives, which contain confidential information, could be of great danger, especially for protected witnesses and some other interests. So that's why it's extremely important to protect these materials properly. Good quality browsing of the database is also of huge importance, so that people can have access to what they're really looking for. And there is another issue that should be raised, and that's the issue of proper safekeeping. Today we have digital technology, but we don't know how long certain media can last. There are new and new media being developed, so it will have to be transferred at some point to a different media. Such archives, the archives of the tribunal, are complementary to all other databases which have been collected so far. At the law faculty of the University of Zagreb, there is a database of digitalized newspaper articles on war crimes. As far as I know, there is also another database, or at least it is being developed, which will have data on monitoring cases of war crimes in Croatia. So to get a broader picture, all of these sources are pieces of the same puzzle in order to reconstruct the truth, or at least the part of the truth.
You have pointed out the important issues of security, and it's an extremely complex and huge archive, and we have an archivist here who knows what this means in technical terms. And I'm glad to hear that you see it as important to have all this together in one place. I would like to go into a little bit a less legal and a little bit less technical direction, and talk about what can you do with archives. Archives as such, you can just put a computer somewhere, you could give access to the documents, they are available already, as Gabrielle has told. But what else can you do, or what is the benefit of having this incredible collection of material, which is audiovisual material, it's written material, it's also artifacts which are in The Hague, and how can you actually use that in a broader dealing with the past process? There are a lot of examples all over the world where archives of truth commissions, archives of tribunals, of national tribunals have been used in, have been somehow processed and made available to the public in a way that goes beyond just producing material for schools. It goes beyond just having exhibitions. It really was also a process of fostering dialogue to bring, and this is a really, really important point that had been brought up several times, to bring it to the youth. We have heard, apparently, these facts are already quite far away. People don't know anymore. This situation you have in Argentina, you have it in Germany. At a certain point, all this terrible thing that happens, they go forgotten, and it is really, really important to keep this alive and to use what is there in an archive to also go beyond what had been achieved by legal processes. We've heard many voices of victims here who in a way were not, couldn't really get out from legal processes what they were looking for. And in using archives and the material that is contained in archives, in different archives, you were mentioning other databases. You could also add a lot of material that have been collected by NGOs and make it accessible in a personal way, telling personal stories, which you can maybe not see in a judgment, but they're still there. They're in a judgment, but you kind of have to make something with it and show it to the public in a way that also touches people. It's extremely important in educational programs that you really personalize the stories, personalize what had happened. I've seen this picture here, these handcuffs. It's an exhibit from Srebrenica, which had been used in the processes. Just using this kind of things, it evokes emotions, it can provoke dialogue, which goes beyond just reading material, just reading a judgment. So I think there's some ideas which could maybe also shape a bit what can be done with information centers which go beyond just having access to documents. Thank you.
I would like to give the floor to Mr. Jozo Ivanovic, the Deputy Director of the Croatian State Archives. So let us hear your perspective. Thank you very much. I will try to keep things brief. Archives come last, so people working in the archives say people end up in graves and documents in archives. I know that we have to make things rational, but we should also bear in mind that people respect graveyards. So if they respect graveyards, this is an aspect that we should also apply to archives. Let me now try and join this discussion about the archives of ICTY. One important objective is met exactly through the ICTY's archives. What the archive does is something that pertains to what any kind of an archive does. We don't want it to end somewhere in a remote location. We also have to think about how we will approach that archive. Is it a part of a larger archive, or is it something that is an independent archive? There is such a thing called an independent archive. It's a collection of experience, document, and so on that sends a message. So in the future, I would hope that ICTY's archive would be an independent archive, because it would share a message, it would extend a message and share certain values. And these values and messages would be kept permanently as a symbol of values that we believe should be a part of public discourse in the future. There are numerous types of different archives. Various organizations and individuals established various types of archives, always trying to say something, always trying to share certain values. It's by no accident that we have had archives from as late as the 19th century, but they did not exist in the Middle Ages, because we had archives and communities appearing in the recent history. This is because we saw the occurrence of different ideologies, historical events, and so on. And this is why archives exist. Archives are a voice that says something happened and it should remain in the future. So there are the actual and virtual archives of the Holocaust, and we don't have one single institution that created such an archive after the Second World War or during it. But here, what the most important thing is this need to preserve the message, to let the message speak and to connect that message to the time and place that it provides evidence to. The time and place that will be remote to future generations, and yet we don't want to make that voice unheard. I think that's a huge success, a very important achievement, and everything else seems to me to be something of a more technical nature. So in this context, we are talking about the archives of the ICTY. Let us take a look at the future. Let us try and imagine the perspective of people who will live in this region. And we immediately perceive a change in perspective, a change in context. And the context will change and change as time goes on. The context we are talking about here is the context of the court, the trials, the war, and the victims and the crimes. There are certain boundaries to all of that, and it all took place in a certain time frame. Once we come to a region because of which ICTY exists, we see that what we're dealing with is a special period of time in the past, which is filled with trauma, but is also documented, remains in the people's memory and remains in the documents kept in the archives of the archive, but also the media. And the archive of ICTY exists in this context. So the question is not what do we do with ICTY's archives, but how do we use the ICTY's archives in the future? How do we manage ICTY's archives in the future, and how do we use it to share certain messages that have to be said out loud? In this area, people will not look at the ICTY's archives as an isolated issue, but as a part of a mosaic or a puzzle that is made up of different elements. But the ICTY's archive is a crucial element, a very important element that is there to stay and is a source of relevant documents. So, to me, this seems a very important thing, and when we make decisions which will have long-lasting effects, we should think about the use of the archives. There is something interesting that was mentioned this morning, and it's natural. Somebody said that we still think about the legal context of it all. I think that the legal context will lose on its importance through time, and I think that the social context will gain in importance. In 2 years' time, we will talk about 100th year anniversary of World War I, which was terrible. But still, our relationship and our view of World War I differs from the point of view people who lived at that time had. And then let's think about the Napoleon Wars and some other wars that we don't have to remind ourselves of. Our perspective of these wars is not equal to the perspective of people of those times who belonged to certain movements or partook in certain ideologies. So this is something that we call historical memory and perspective. There are certain things that we find important at a given point in time. Later on, they're a part of a perspective. Later on, there is a selection. And later on, we have to make sure that we have an archive of facts and documents that make it possible for us to define strategies for the future. I will not go into any technical details now. I think that the conservation of digital documents and safety of data is not a topic for this conference, but I would like to pick up on something I said earlier on. One thing keeps being discussed among archive people. We like to say that archives safekeep the truth. If you look for things well, then you can find the truth. Over the last 20 years, that formula has been questioned a bit. It has been shown that it is quite difficult to say what objective truth is, and what kind of truth would be a link for a quite diverse community. And truth is something that is shifting. Something that is considered to be true at one point in time, at one point in history, is no longer perhaps considered to be true, or is perceived and interpreted differently 20 or 30 years later. Let us think back to early 90s. The war broke out. We were embittered by Europe's behavior. We were embittered by the world's reaction, who seemed disinterested in our problems. However, 6 months later on, in a different part of the world, these things happened, and yet we were disinterested. And 6 months before that, we were wondering why Europe was disinterested when we were at stake. So the question here is this: what is the right strategy? Do we have to formulate an all-encompassing general truth, or should we just leave the door open and make it possible that parallel interpretations and different initiatives could exist simultaneously? There is yet another perspective that is shared by contemporary archivists, and this is: what do we preserve? They consider this particular issue, and they're never satisfied. We are never satisfied. We always are on the lookout for general criteria. We're always on the lookout for a general ground, which is so safe and so certain that all of us will agree what to keep for posterity and what not to keep. If we reconsider, we will not feel the drive to take this central view. We will leave people, different people, preserve what they feel to be their legacy, their heritage. I hope this is the view that will be taken, because then value judgments or assessments are no longer in the hands of one group of people. The responsibility gets dispersed over different people. And also, we will have people who will have certain value judgments, and they will then produce their own archives. Thank you. I would now like to say one thing regarding consultations on what the right solution would be. We had some public consultations, consulted with human rights NGOs, and we sort of agreed that there should be one part which is publicly available, which will be a part of a special archive which still does not exist. And then human rights organizations, info centers, will get a copy so that they can have that and indictments, first instance judgments, reports from trials, and so on, because you can find them on our websites alongside Supreme Court judgments, alongside recollections of people regarding the war. The important issue is how archive contents will be presented. So now I'm not talking about the contents, I'm talking about how it will be presented, those parts which are publicly available in the future. When governments consider this, they should not be against human rights organizations having access to these documents. Because we have to decide who takes ownership over these documents, the UN, governments, people. And one more thing I would like to share, one very interesting and exciting project for archive people regarding archives on the Holocaust. The leading organization is an institute from the Netherlands. It will be a project lasting up until 2014. It's worth several millions euros. It has several different sources of finance. The point of that project is to make as much information available to public as possible, because information provides you with ideas. In order to get the info centers going, information centers, the first question will be, how do we get the money? How do we get financial backing? What they should think about is cooperation with the archives, human rights organizations, universities, because together they can do much more, with the aim of making it all publicly available to the public in a transparent manner. And I'm not talking about sharing documents. I'm talking about then developing videos, video clips, PowerPoint presentations, something that will tell people a lot based on facts established beyond reasonable doubt, without any further interpretation. So I would like to give you enough time for discussion, and I would like to kindly ask you to join in the discussion. Thank you. Gordan Boduk. Thank you. I raised my hand because I always do that. It's not like I like listening to my voice. I just think perhaps what I say will be beneficial. But here I have a question. Victim organizations do have their own archives, and that's always true. Victim organizations have shared their archives, I think, one way or the other, with institutions, with organizations, and in different proceedings. But let us be aware of one fact. Victim organizations have not been surrounded by proper circumstances over the last 15 years or so. They were not able to do as much as they could have regarding the residual mechanism, regarding collection of documents and so on. The role of victim organizations, I'm trying to say, does not end once we have judgments. For example, missing persons issues always exists, even if the person is found, and even that has not yet happened. The story does not end. One of the proposals we should bear in mind in this is this. When we talk about victims and their right to compensation, recognition, and everything else, we should introduce yet another element. That's my suggestion. This additional element would be related to the archive. We should find additional financial sources to back victim organizations in their cooperation with the archives, because they do have a lot to say with respect to reconciliation, documentation, and so on. That's one thing. And the second thing I would like to say has to do with credibility of the archives. Over the last decade or so, I have had numerous discussions with people, and the outcome is one thing. These official documents that we will find in the archives. I hope we all understand. But the verification criteria when we collect data is a different issue. The transparency of that whole process regarding the outreach program has never been that clear or transparent. For example, we know that there are some security and safety issues, data protection, witness protection, and so on. But still, the question remains, what happened with information that went through the government institutions and so on? Did they also come from NGOs? Well, who verified all that? How was this marked? How was this assessed? Has the validity and credibility been assessed? This is something that remains unclear to us, the public. And I think this is an issue that needs to be addressed if we want to do the follow-up of credibility and so on. Vesna, can I say one more thing? The sensibility or awareness raising has to do with a question that the public asks in Croatia and elsewhere. You see, the ICTY announced their final judgment for Gotovina and Čermak for the 16th of this month. And from the 18th to the 20th this month, we will have memorial days and anniversaries in Vukovar and throughout Croatia. What were the reasons to choose the 16th of November for the publication of the final judgment? Has there been any sensibility? Has there been any intention behind it? Because perhaps the whole follow-up is jeopardized. I don't know. Perhaps other people would like to share their opinions. I don't see any hands in the air, so I would like to ask our panelists to share their closing remarks. Gabriela McIntyre.
Thank you. I think for me, one of the main issues that has come out of this conference is the visibility of the information that's available, because there is a wealth of information that is available. It is through a website. The website might be cumbersome. I find it easy. So it's about how we make the information more visible. And I think, that's really a role for civil society in many respects. The tribunal has its outreach program. The tribunal, like civil society, has always had to raise funds for its outreach program. It's never been part of its budget from the United Nations. In relation to your question about, how do we know about the credibility of the material in the archive, I think the judicial archive is where the evidence has been tendered in the record, and that has been tested and evaluated by the judges. But there's a whole other archive, which is the prosecutor's evidence collection, and that's a huge archive, and a lot of that evidence has never been introduced into court. And it's still not clear. I know my colleague was saying that confidential material, Rule 70 material, which is material that the prosecutor is not allowed to tender into evidence in court without the provider saying he can do so. Basically, he's generally used it to generate new evidence that he can tender. It's unclear. I asked the prosecutor before I came what was going to happen with his huge evidence collection. Was there an idea, to give back, material, or what was he going to do? And he said they were developing their policies. I think at this stage they're still talking to providers of information to work out what's the best solution. But they're also guided by the principle, a fundamental principle of archives, that you don't split it up and destroy the archive. But there may be a process. I know Elizabeth's very concerned about the prosecutor having original documents and that they should be returned. But yeah, thanks.
Gospodin Markovic.
I'd just like to say once again that archives are extremely important for the work of the residual mechanism going forward and for future prosecution of war crimes on domestic earth, on the one hand. On the other hand, archives are extremely important for the countries of the region and the history of these countries. As far as Croatia is concerned, we provided the prosecutor of the ICTY everything they wanted. And with the most sensitive documents, which were classified as secret or confidential, which dealt with issues of national security and other important national or individual interest, we always pointed out Rule 54 bis, so that archives can be then returned to the provider, which is the Republic of Croatia. The information centers are one of the ways in which different stakeholders, different actors in the societies of the region could use, starting from victims, scientists, all the way to historians. And this single corpus of information is extremely big. A lot of energy and money should be put into that to have it all translated into regional languages. Whether we are going to be able to reach an agreement on that or not, it remains to be seen. I'm afraid that the discussion at the end of the day will boil down to funding as much as everything today, because everything is viewed through the financial perspective. But I still think that it would be good that these information centers do get set up in the entire region. Information centers, to some extent, would solve with the issues we talked about today, that the public is not well informed, that the expert public, including students of law faculties, do not know much about the work of the ICTY. Everything that's happened in the past and where mistakes were made, and I think that, for example, the Croatian national television has made a big mistake by not streaming war trials, at least the big cases which are relevant to Croatia. I think that was a big mistake. In that respect, in solving and in not repeating the mistakes of the past, it would be good to have these video footage as part of the database, which will be then made available through information centers. Thank you. Thank you. Mr. Bolancic. Maybe it would be good just to repeat once again that the archives of the ICTY are a fact. It's part of our history. It would be really important to make it accessible to people from all of our countries. In that way, those who are interested in history or who have personal reasons do not have to go abroad to find something about events that took place in our country or countries. There is one more thing that's important which I'd like to add. These materials should be prepared for users. They should be as user-friendly as possible, because the archives are going to be huge. Apart from the archives, some materials should also be prepared which would make it possible to people to find out what they want to know.
Gospođa Baumgartner.
Ms. Baumgartner?
I fully agree that an important point that came out is how do you make it visible? What have been mentioned, what happens with all the information that is contained in archives of civil society. I wouldn't say just NGO. There's a lot of information in the hands of civil society, which is complementing, or which can complement the archives of the ICTY. And I do not agree with Gabrielle that this is a responsibility of the civil society to do something with it, to actually really use and make it accessible to a broader public, to use it in a way that fosters dialogue and maybe reconciliation that needs resources. And I think it's partly also a responsibility of the state towards the victims, towards the society, to keep this material somehow available and alive also. And I wouldn't say it's the responsibility of the civil society to do that. There are a lot of examples where archives of official bodies have been combined with archives of civil society, of the church, for example, in Chile, you have a museum which combines the Truth Commission archives with church archives on what had happened during the military regime. So there are examples where it's made available through a museum, through a documentation center. But this needs, and there I agree, this needs funding, this needs serious planning. And so it is an important factor of what do you do with all this material.
Thank you. Gabriella McCain.
Yeah, I just wanted to clarify, because Elizabeth disagrees with me. What I mean is civil society has a role in making it more visible. You know, that's what I meant, not you have a responsibility to do everything. I meant you can raise the visibility maybe more than governments are prepared to do. Thanks.
I think the crucial thing about this archive is shared with all other archives. The archive has to try and define the ownership that it holds. This depends on the micro community that supports the archive in a certain society. We here are members of a micro community. There is a nice definition of archive, and this is a community of people interested in the same topic or the same values. Thank you. I think this is a very good closure for this panel. This group will try and further monitor what goes on with the archive. I hope that we will support each other so that information centers are up and running as soon as possible, collection of information continues, and disclosure and dissemination of information is done as much as we can, because it's an important part of reconciliation and building trust. Thank you very much for participating in this panel, and I would like to take this opportunity to thank Judge Bokar for having attended this conference. I would like Mr. Bokar to say a few things and to join us here.